Good evening, everyone, and welcome to the National Bar Association's Tech and IP Summit in celebration of Black History Month. I hope that everyone is staying safe and doing well. Our members in Texas, our thoughts and our prayers are with you. My name is Danielle Bolger, and I'm the current chair and last year's interim chair of the Intellectual Property section of the National Bar Association. I'm also an IP senior associate at Arent Fox in Washington, D.C. In a former life, I worked as a journalist, so naturally I have a passion for the media, the internet, retail, and technology. I consider myself a true brand attorney who helps clients grow their assets, brand assets, as well as manage their copyright and trademark portfolios, understand the law, solve problems of first impression, and enforce their rights within this exciting backdrop of the internet and the First Amendment. For those who are guests today, the Intellectual Property section of the National Bar Association is just that, an arm of the National Bar Association, the nation's oldest and largest national network of predominantly African-American attorneys and judges. The organization represents the interest of over 60,000 lawyers, judges, law professors, and law students. The IP section is comprised solely of volunteer IP professionals who dedicate their time and talents to educate each other, our community, and create and build opportunities. We do this by offering and hosting CLEs, webinars, networking events, and facilitating connections between attorneys and corporate law departments and law firms. We are so excited for today's Tech and IP Summit. It's no secret that we're in the midst of a global pandemic that's changing how our companies interact and function permanently. For context, a recent survey by the Computing Technology Industry Association reported that the global technology industry is forecast to reach $5 trillion in 2021. COVID-19 has particularly been a catalyst for business transformation, with 76% of businesses planning on long-term IT changes, which arguably will or have already impacted consumers or interactions with them. I think a common misperception is that tech is only in Silicon Valley, and while it is there, I think it's fair to say that tech is everywhere. We see it in the financial industry, how we now do our banking, retail, how we buy our groceries and clothing, entertainment, how we watch television and movies and play games, consumer electronics, in the food and beverage industry, and pharmaceutical industries, among others. The breadth of tech and IP is particularly represented in tonight's speakers. We have a great lineup of attorneys who are in-house at companies, at law firms, and at the government. We wanted to do something a bit creative with the format of tonight's event in view of our vast array of audience members, including practicing attorneys, executives, and law school students. The first portion of our event will feature speakers from Microsoft, Amazon, and Facebook speaking on artificial intelligence, e-commerce, and content protection. The second portion of our event will feature attorneys from different fields of legal practice, including the USPTO, JP Morgan, Venable, one of our sponsors tonight, and Microsoft. We will then turn to your questions for our panelists, followed by closing remarks. Feel free to interact with each other in the comments. Thank you again for joining us. Without further ado, let's turn to hot topics in tech and IP. We'll be starting with Charlie Bingham, Principal Corporate Counsel at Microsoft. Charlie, over to you.
Good evening, everyone, and thank you, Danielle. My name is Charlie Bingham. I'm currently Principal Corporate Counsel for Microsoft's Global Partner Solutions Sales and its U.S. regulated industries teams. As a member of their corporate and external legal affairs group, my practice focuses on advising internal business clients and our partners on complex cloud computing and devices agreements, general legal matters, including advising on IP, ethics, data security, privacy, compliance, software licensing, consulting services, and a variety of corporate and contractual matters. And I'm more than willing to answer questions about kind of my practice as we go on. But getting to the hot topic of AI, you can go to the next slide. This is a quote that our CEO put out with his book, The Future Computed, a couple of years ago, and it talks or speaks to the importance of artificial intelligence. It's just not another piece of technology, but we view it as one of the world's most fundamental pieces of technology the human race has ever created, because it's going to allow us to do things much faster in a much efficient way that can impact all of humanity. You can go to the next slide. And AI, you're going to see, is used everywhere, almost in every industry. We have this term that Microsoft has coined called digital transformation, and we're seeing that take place now. Many of the industries and entities that were kind of fighting this digital transformation really took a hard hit during this pandemic when we had the quarantine. And so what digital transformation really means, oversimplification of it, is just moving everything to the cloud and being able to automate a lot of processes that require human resources. So we see this, a key example is the first one is virtual assistants. Instead of having a human that needs to answer at a call center that needs to answer a call to help support people, you can have what we call chat bots that when you log on to an internet site, I'm sure you've seen it before, you'll see this person, hey, hi, I'm Sally, how can I help you? And you can type in frequently asked questions and she will give you answers and direct you and point you to the right place. So AI is used everywhere, from your cars, your cell phone, for those of us who have the new Apple phone, and I guess Android has had this for a while. They use biometrics. You can unlock your phone just by looking at it, and that's a mixture of biometrics and facial recognition. So it recognizes who you are, and because it recognizes you, that automates turning on the phone and unlocking, so you no longer have to put in a passcode. That's just another example. We all have, I think, heard of Tesla and their autonomous cars. And so AI, the takeaway is that AI is used everywhere. Now you can go to the next slide. We're here to talk about kind of some of the hot topics, but AI has some issues. Before I turn to some of the areas that we use AI and the hot topics, and some of those are right here on this slide. You can see, like, personhood. When you have this chat bot, for those that can remember, Microsoft put out a chat bot early on a couple years ago, and within 24 hours, because with data sets and artificial intelligence, it's essentially garbage in, garbage out. So whatever type of data you feed into the algorithm, then that's what it's going to put out. And after 24 hours, I think it was on Twitter, the chat bot was using some very derogatory terms because that's how people was interacting with it. Another big issue is bias and inaccuracies. And you may have seen the articles in the news talking about how through artificial intelligence or Google or Google searches, because people have put in certain terms, now that algorithm has developed and has shaped to where if you search Black people, you'll get images of monkeys, things of that matter. So those are kind of some of the issues that we are working out with artificial intelligence. And one of the things that you're going to see in the future is there has to be some type of regulation and some type of responsibility as well. Moving on to the hot topics and kind of where we're going to see artificial intelligence in 2021, 2022, 2023. We've seen it, the importance of AI and the role it's played in the vaccine development for COVID-19. This is by far, it typically takes years, if not decades, to develop a new vaccine. But by March 2020, vaccine candidates to fight COVID-19 were already undergoing human tests just 3 months after the first reported case. And this was because of artificial intelligence models that help researchers analyze way more data than they typically could if they were doing it by hand. So that's just one example of where we're seeing AI play out. The other one is in fully automated driving and the rollout of robo-taxis. And this technology continued to mature in 2020 with the industry's leading companies testing driverless cars and opening up robo-taxi services to the public in various cities. We don't see it as much here in the United States, but globally, this is really a thing. And the fully automated driving enables rides without a human safety driver on board. And it's artificial intelligence and making these cars smarter and react in different situations and scenarios will be necessary for the scalability and commercialization of autonomous driving. Another area is applied natural language processing. And essentially what that means is helping computers to understand our dialect, what we're saying, what we're trying to communicate. And in 2020, these systems were becoming more advanced due to data sets, artificial intelligence data sets, to not only interpret what a person is saying, but now they're, with the combination of visual understanding, they're starting to comprehend the meaning through tone, through the volume, the speed, the rapid pace with which a person speaks. So it's developing further and further, thanks a lot to artificial intelligence. And then the big one and the last one that I would say is a hot topic is quantum computing. And it would take a rocket scientist to explain exactly what quantum computing is. I've undertaken that task. It's kind of like things change, numbers change. It's no longer the zeros and ones that we use to program traditional computers. The numbers could change at any time. But what you need to understand and take away from quantum computing is if regular computers allow us to do things faster, these are going to be like super computers and allow us to analyze vast amounts of data in a much quicker time. So those are the hot topics for artificial intelligence coming up.
Thank you, Charlie, for that great overview. You mentioned AI and dialect, and that makes me think of trademark law, because we usually don't think about AI and trademarks, but the core tenet of trademark laws is likelihood of confusion, and it looks at how consumers interact with brands and in the purchasing process. And you mentioned dialect. So what happens when AI actually becomes a computer, when your Amazon Echo ends up buying a product? Will AI take the place of an average consumer? Can it be confused? I guess all that to say, what do you think are some of the biggest implications of AI in your particular line of work at Microsoft?
In my particular line, it's AI is more data sets, analyzing data sets, because we are a cloud service provider. And so the biggest issues is, and our president wrote a book about this, artificial intelligence. Again, one of the big key takeaways that people should understand is artificial intelligence is based on the data that you feed it. It's an analytical tool. And garbage in, garbage out, good data in, good data out. And whatever that product is that results from the data sets could be used to help humanity. But they also can be used, and the name of his book is Tools and Weapons. He talks about this, how, let's say, for example, facial recognition. It could be used as a very helpful tool, but in the wrong hands, it also could be used as a weapon. And so one of the big issues that I see with artificial intelligence is that in the future, very quickly, we are going to need to ring fence and put some guidelines around these companies that use artificial intelligence to make sure they're using it in an ethical and moral way, and not as a weapon which could be used against a particular demographic.
Lots of implications. And I have a feeling AI won't just be a hot topic today, but for many years to come. Thanks again, Charlie. We will now turn to Kibaru Smith, who is the director of Amazon's Counterfeit Crimes Unit, for our e-commerce update. Over to you, Kibaru.
Thank you, Danielle. And hello, everyone. It's a pleasure to meet you all virtually and to talk about my work with Amazon with the Counterfeit Crimes Unit. Again, my name is Kibaru Smith. I am a 2001 alum of Texas Southern University Thurgood Marshall School of Law. By way of a little more background, before I joined Amazon last June, I was a career prosecutor working in Texas, started in the district attorney's office in Fort Bend County and Harris County, Texas. And then after that, I joined the U.S. Attorney's Office in Houston. I'm currently sitting in Tyler, Texas right now, dealing with these weather conditions. But in my current role, I am based in Washington, D.C. at Amazon's HQ2. After I left the U.S. Attorney's Office, I worked at the Department of Justice's Computer Crime and Intellectual Property section at Main Justice. And while there, I did a lot of trademark counterfeiting criminal prosecutions, essentially going after criminals who used brands' trademarks to sell them as legitimate when they were in fact fake, essentially a form of fraud. There is a criminal statute, a federal criminal statute that we used. And a lot of my work focused on health and safety violations, counterfeit medicine, counterfeit pet medicine, but also counterfeit products such as counterfeit iPhones and so on. And as a result of that work, I was asked to join the newly formed Amazon Counterfeit Crimes Unit, and I now serve as the director of the Amazon Counterfeit Crimes Unit. So this session will talk about e-commerce, and we'll add on e-commerce and kind of compliance and customer trust, that piece of it. And several years ago, if I were doing this presentation, I'd spend time talking about e-commerce. But now that we live in a day and age of COVID, we've been getting a lot of our goods from e-commerce platforms like Amazon. No need to talk about what e-commerce is. We can go ahead and go to the next slide. As I mentioned, I am with the Counterfeit Crimes Unit at Amazon, and I am the director. And our team is a team of around 15 people who sit all over the world, from Seattle, Washington, D.C., London, Milan, and China. And we are a team that focuses on working jointly with rights owners and brands to go after infringers or counterfeiters who attempt to use the Amazon store to sell counterfeit goods. We acknowledge that most of our third-party sellers, the people who do business as sellers on the Amazon store, are legitimate, good-dealing business people. But then there are some who evade our internal systems in an attempt to sell counterfeit goods. And our role and purpose is to work directly with law enforcement, whether it's state, local, federal, and even international law enforcement like Europol and Interpol, to pursue these bad actors. We make joint referrals to law enforcement, and we also work jointly with rights owners to file joint civil lawsuits in an effort to deter and claw back whatever ill-gotten gains have been received by these bad actors. As I mentioned, we work internationally. There is no corner of the globe that we will not touch to pursue these bad actors who attempt to either defraud brands and also sully the good name of Amazon. And so we will pursue bad actors in the United States and internationally. And as a matter of fact, we've made several joint referrals to U.S. law enforcement on the state and federal level, and also referrals to international law enforcement such as Interpol. We do seek partnerships with brands. We do believe that partnering with brands, whether it's a small brand, a large brand, or a medium-sized brand, is the best way to pursue these bad actors. And we can go to the next slide. And we do that by asking that rights owners make purchases and make confirmed counterfeit purchases. And that typically is a gateway for us to pursue these bad actors. As once we identify that an item is purchased from Amazon and it is in fact counterfeit, we can go after the seller, close the account, block funds, and pursue either a criminal referral and or a joint lawsuit. And we've done that since we've been stood up. So test buys are one of the main ways we open cases and partner with rights owners. We also can file notices of infringement on sellers' accounts, look at reviews placed by customers who shop on Amazon, notifying us that they may have purchased a counterfeit, and other internal data that helps us identify whether a seller is selling counterfeit information. One of the big perks about working with our Counterfeit Crimes Unit is that we can exchange data with rights owners and law enforcement in real time in an effort to identify these bad actors. These infringers are typically nimble, they're opening and closing accounts, and they're finding new nifty ways to evade our systems, whether that is by using false invoices, fake IDs, and also using social media platforms and other e-commerce platforms to sell counterfeit goods. As the slide mentions, since we've been stood up since this past June, we've partnered with several brands such as Yeti, the mug company, and the outdoor sportsman company. We recently filed a lawsuit late last year against infringers who were based in California, who were selling counterfeit Yeti mugs. We recently filed a joint lawsuit against counterfeiters who were selling Dutch Blitz card games. This is a small mom and pop company based out of Pennsylvania, and we were able to file several lawsuits against infringers who were infringing on their brand. KF Beauty, which is a cosmetic brand, we've partnered with them on a joint civil suit, and Ferragamo, and you'll see more about that lawsuit in a couple of minutes. So as I mentioned, we pursue both civil litigation and criminal referrals to law enforcement. Next slide. As I mentioned, some of our recent filings, one was a Dutch Blitz, which we filed February 10th of this year. Here you can see the quote from the Dutch Blitz owners. We are seeing real results from Amazon's work to eliminate counterfeit products from being sold in their store. E-commerce is an area where third-party sellers are allowed to do business and sell goods in a virtual space. And as a result of that, many criminal actors attempt to use this space to infringe on the rights of others. And you can see that this quote is a great example of the work that our counterfeit crimes unit was able to do with the Dutch Blitz company. Next slide. Another example, as I mentioned, was the Ferragamo lawsuit that we filed with Ferragamo, our counterfeit crimes unit. In this instance, you'll see that infringers attempted to sell counterfeit Ferragamo belts, a very well-known Italian luxury brand. In this suit, at the time of the press release, our Vice President Dharmesh Mehta stated, "We do not allow counterfeit products in our store, and we have made it crystal clear that we take aggressive action to hold accountable bad actors who attempt to evade our proactive protections." As I mentioned, Amazon has many internal protections, a lot of them tied to AI, as was just mentioned moments ago. And sometimes these tools can be evaded by nifty criminals. And it is our role to use, as the CCU, to use these external enforcement efforts to pursue these bad actors through civil suits and through criminal referrals. We will continue to fight to protect intellectual property rights from small family-owned businesses through Fortune 500 companies. Next slide, please. I also mentioned our law enforcement data sharing. It's key to our team and our mission as a counterfeit crimes unit and our mission to disrupt and dismantle counterfeiting organizations to work closely with law enforcement. And as a result of that, we've worked, for example, with the United States Homeland Security Investigations and the National IPR Center, Europol, Interpol, and local state law enforcement. And what we do is we share data with them in real time once we've identified a bad actor on our store. And the purpose is to send a strong deterrent message, similar to like what I did as a prosecutor, to disincentivize sellers from selling on our store. That is our role. Most recently with the Super Bowl, we worked with the National IPR Center in a data sharing mission and platform to share data for infringers who were selling counterfeit Super Bowl memorabilia during the Super Bowl. That was a couple weeks ago. We partnered with the with the IPR Center in Operation Fulfilled Action. We also do quarterly disclosures of data of bad actors to law enforcement in China, the United States, Canada, and in Europe. So it's key to our work that we partner with law enforcement and share data with them in real time. Lastly, I can't talk about several of the ongoing criminal investigations, but I will say from a very high level that we have been able to work closely on several law enforcement search warrants and raids that have resulted in multi-million-dollar seizures of counterfeit goods from people who were hoping to sell these counterfeits to U.S. consumers. And that is our mission, to disrupt and dismantle counterfeiting organizations. I look forward to answering questions about our Amazon Counterfeit Crimes Unit. It's been a pleasure talking to you. I will leave you with this note. Tech law, or to work in tech law, you don't need to be a techie. And I'm a perfect example of that. So keep that in mind for especially those of you all who are in law school, who see yourself working in-house in a tech base or a tech space, You don't need to be a techie to work in tech law. So I look forward to talking to you once we open it up for questions. And thank you for allowing me to tell you about our Amazon Counterfeit Crimes Unit. Thank you.
Thank you so much, Kibaru. That was great. The late Coco Chanel once said, if you want to be original, be ready to be copied. And I think that still holds true today. In my practice, I've noticed an increase in creative takedown procedures by companies, something that's not currently mandated in trademark law, like it is in copyright law, for example. Do you think more companies will start to adopt programs like Amazon's brand registry or something similar to attack infringing goods?
Yes, to answer your question, I can totally see companies building out more robust enforcement teams and internal mechanisms. The fact of the matter is that e-commerce is here to stay, even when we get past COVID. And the fact is that there's going to have to be e-commerce compliance, which will mean that companies will have to do like Amazon and build very robust brand registry style programs, and also units that go after infringers. I'm proud to be a part of a counterfeit crimes unit, which is a leading influencer in this space, using external efforts and partnering with law enforcement to do that. But to answer your question more directly, I do foresee that as we see more e-commerce platforms develop and grow, that they are going to have to develop more robust response teams to go after bad actors who attempt to use those platforms to sell illicit and fake goods.
Absolutely. Thanks so much, Kibaru.
Thank you.
Next, we have Erica Stallings, Associate General Counsel of Music Product at Facebook. Erica, thanks so much for joining us. Over to you.
Thank you so much. I just want to say really quickly, thank you so much to the NBA for having me as a panelist this evening. I want to use my time to talk about two topics that I think are really worth keeping an eye on for any of you who are working on online content and copyright issues, or if you're interested in that area of the law. I will just quickly take a minute to explain a little bit about the work that I do at Facebook. I'm an associate general counsel and I work on music products. And what that means is I work across our various product teams across the Facebook family of apps. So that might be Reels, it might be Instagram generally, our premium music video program, Messenger, et cetera, to make sure that we are in compliance with our contractual deals with music publishers and labels, and also working cross-functionally with our copyright teams, privacy teams, et cetera, just to make sure that we are both from a contractual standpoint compliant and also from a legal standpoint compliant. Prior to joining Facebook late last year, I worked at Broadcast Music, which is the country's largest performance rights organization. So I have experience on the rights holder side. And before I transitioned in-house, I worked for 6 years in private practice with a focus on litigation and online copyright and trademark enforcement. So this evening, I want to cover two topics that I think are really interesting. And the first of those is the CASE Act. Next slide. So I know we have a mix of practitioners and law students here with us this evening. And so the first topic I wanted to talk about is the CASE Act, which stands for the Copyright Alternative in Small Claims Enforcement Act of 2019. Although it says it's the Act of 2019, it was actually passed by Congress in December 2020 as a part of the Omnibus Spending and COVID-19 Relief Bill. And I think for that reason, it hasn't gotten a lot of press attention, but as I'll talk about, I think it has some very interesting implications for online service providers and anyone practicing in copyright generally. So under our current regime, copyright infringement cases have to be pursued in federal court. And obviously for someone who may be a small individual copyright owner, it can be very expensive and time consuming to have to pursue a copyright infringement claim in federal court. And the internet has obviously created numerous opportunities for infringement. So going all the way back to 2013, the US Copyright Office had actually issued reports suggesting the creation of an alternative claims court for copyright infringement cases under a certain dollar amount. And so this bill that was passed in December of 2020 actually creates an alternative claims board within the US Copyright Office. The Copyright Office has 1 year to actually establish the board. So it's likely that we will not actually start seeing cases coming out from the CASE Act until 2022. The legislation states that the board needs to be made up of 3 attorneys, 2 of whom must have a background in copyright law. What's really interesting about this is that since it is an alternative form, it is a voluntary process. So if you are a defendant who is served with a claim under the CASE Act, you have 60 days to opt out. And for parties who do not opt out, it essentially will go into a very arbitration-like process. Now, the statutory damages that one can receive in this alternative form are limited. So if you pursue a copyright infringement claim in federal court, you have maximum statutory damages up to $150,000. If you are pursuing statutory damages in this alternative form, you are limited to a maximum of $15,000 per work and $30,000 per claims for works that have been timely registered with the Copyright Office. The statutory damages are reduced by 50% for works that are not timely registered. And the jurisdiction that this alternative form has is limited. The board can hear claims relating to copyright infringement, declarations of non-infringement, and misrepresentation claims under the Digital Millennium Copyright Act, which I will come back to in a second. And it's also worth noting that this forum cannot issue injunctions, but the parties can agree to voluntarily cease infringement, and they can have that ruling issued by the board. So one of the reasons that I actually think this legislation is so interesting is because of this point here, that parties can pursue claims for misrepresentation under the DMCA. So if you're not familiar with the Digital Millennium Copyright Act, it is essentially, it's legislation that was passed in 1998. It is essentially the underlying legislation that allows the internet to operate as it does today. It creates a notice and takedown system. So for online service providers or online content providers like Facebook, right? We have a blanket liability from content that is uploaded as long as we comply with the DMCA. And one of the main provisions under the DMCA is that a rights holder can send Facebook or other ISPs a notice saying, hey, this user-generated content that was uploaded is infringing, please take it down. We're obligated to take it down. And then there's a whole process where the person who uploaded it can come back to us and say, no, I believe that my use is justified either under fair use or because I own this content. And there's a whole dispute resolution process that plays out. But one of the provisions under the DMCA, Section 512F, allows someone who uploads content to file for damages if they feel that the DMCA takedown notice contains misrepresentations, right? But this is really interesting because often for rights holders, they send out blanket DMCA takedown notices, right? Because many services rely on algorithms to sort of monitor for infringing uses. So even though this 512F provision has existed since the creation of the DMCA, we don't have a lot of case law under it because it would be so expensive for an individual user to bring a claim for misrepresentation. There is one really famous case involving a clip of a Prince song that was litigated in the Ninth Circuit under 512F, which did result in a ruling that when a rights holder issues a DMCA takedown notice, they are obligated to consider whether the use would fall within the fair use exceptions under the Copyright Act. But generally, we have not seen a lot of case law under 512F. And so one thing that I think is really interesting is that now that smaller users are going to have the ability to pursue misrepresentation claims in the smaller and cheaper form, we might start to see some really interesting case law. And obviously that will have implications for rights holders who will have to make sure that in their effort to make sure that infringing content is not being uploaded and that they're monitoring ISPs for infringing content, that they're not running afoul of the misrepresentation misrepresentation requirements in the DMCA. Next slide. The other really huge piece of legislation that's similar to the CASE Act is pending, but has really wide-ranging implications for ISPs and companies like Facebook, is the Copyright in the Digital Single Market Directive, which is also referred to as Article 17. So in 2019, the European Parliament passed legislation requiring each EU member state to enact new laws impacting online copyright usage. And what I laid out here is some of the highlights of what Article 17 requires ISPs to do. The first is that it requires ISPs to use best efforts to obtain licenses from right holders for content that appears on their sites, including when that content is posted by users. It also requires ISPs to use best efforts to ensure the unavailability of specific works that have been identified by rights holders. And it requires ISPs to make best efforts to block future uploads of content that have previously been removed pursuant to a takedown notice. It also creates exceptions, right? So even though you've got to use best efforts to prevent infringing content from being there, it also recognizes that there are certain permitted uses of copyrighted content, including parody, criticism, and quotation that should be allowed to stay up. And for each EU member state, they have until June of 2021 to pass legislation that complies with Article 17. So there's a few issues that arise out of this that impact ISPs, companies like Facebook. And one of those is that the legislation, Article 17, doesn't really give a lot of detail on what is defined as best efforts. And so for my company, and I'm sure others, we're sort of trying to monitor the various legislations that are coming out from each of the member states to try to gain clarity as to what qualifies as a best effort. The other interesting complication is that obviously because each EU member state is going to be passing their own legislation, you're going to see probably different requirements as to what qualifies as a best effort across the various member states. And so for a company like Facebook, we have a program that we use called Rights Manager, which helps us to manage the upload of user-generated content, which allows us to comply with our obligations under the DMCA. We could potentially be living in a world where we might have to have different rights manager programs for each of the different EU member states, depending on what requirements each of them drafts. So for example, Germany recently released a draft of their proposed Article 17 legislation, and they actually have defined up to the second of how much work could be allowed as a de minimis use under Article 17, right? Which again, for companies like Facebook or other online content companies that rely on algorithms to help monitor this, right? You may see the need to lower or increase scanning thresholds. There's also been a couple of EU member states that have actually sought to opt out of the Article 17 requirements because they feel that the requirements would actually have a chilling impact on free speech. So there's currently a pending case that Poland has brought against the EU to be able to opt out of Article 17. So I think for anyone here who practices copyright law or deals with online content issues, just really keeping an eye on all the various draft legislation that is coming out. Because although, obviously at this point, many sophisticated companies are going out there and are obtaining licenses, I think, for example, this requirement for number 3, right, best efforts to block future uploads of content that's been previously removed. There's still a lot of questions about whether that would cover a derivative usage. What do you do if you've taken content down and a user just renames it and the algorithm is not smart enough to pick that up? Does that expose you to liability? So I think both this and the CASE Act are pieces of legislation that we do not know the full impact of, but are certainly going to have a major impact on how ISPs and sites that rely on user-generated content operate in years to come.
Thank you, Erica. That was an excellent overview. There's so many updates in copyright law, so we really appreciate that. I know personally in recent years, it seems as if there's been an uptick in copyright infringement lawsuits, including for frivolous claims. Do you think the CASE Act could incentivize third parties to bring even more lawsuits because this new process is arguably more streamlined?
You know, it's really interesting because I have been keeping up with this legislation for that reason. I mean, even if I take my attorney hat off for a second, as someone who spends a lot of time on social media, I think you often see people not necessarily understanding what constitutes copyright infringement. So I fear a little bit that the CASE Act may create incentives for copyright trolls to bring cases in that forum. I think that will be tempered by the fact that there is the opt-out mechanism for defendants. It's not, no one can force you to participate in that process, which I think will reduce that incentive for trolls. But I do think it will provide a way for, smaller individual owners, to potentially seek some relief that they probably aren't able to get now, right? When you think about the cost of actually finding an attorney who will take a case and then filing that in federal court.
Absolutely, those costs can definitely add up. Well, thanks again, Erica, and thank you to all of our speakers for our Hot Topics in IP section of tonight's program. We will now hear industry perspectives during our Day in the Life of a Tech or IP Attorney panel. This part of the program will be spearheaded by our board member, Justin Pierce, who also served as the chair of this section 2 years ago. So over to you, Justin.
All right, thank you, Danielle, and good evening and afternoon to everybody. Thanks for joining. We're hoping you enjoy this sort of change of pace during a Zoom or video conference. One of the biggest things that I hear all the time in my current day-to-day life in the job is that I'm burnt out on Zoom. So we thought, what better way to start off with one type of presentation where you're getting slides, but then turn it to a panel where you get to hear a group of people, and a really diverse group, I'll start with that, of people from different backgrounds, all great examples of how you can find a different pathway in doing intellectual property or tech law. And so without further ado, let me introduce myself and then dive into the panel. So I am Justin Pierce. I'm currently an IP attorney who's worked at the Venerable Law Firm for much of my career. I'm currently the chair or co-chair of our intellectual property division. For a number of years, I actually worked in-house as well in various places around the world with Sony. And now in my current role, manage all that we do at the Venerable Law Firm with respect to attorneys in the fields of patent law, trademark law, copyright, and litigation and transactions in that very area. And so this particular panel is something that I've been looking forward to, and for a couple of reasons. One, here we are in the National Bar Association in the month of February, Black History Month, and what a great way to kind of show the sacrifices of our ancestors and of our parents and grandparents by showing you the very people that you have on this conference in front of you. I think many of them would probably be a little embarrassed to say, I'm sure whether I know them or not, their parents and grandparents are proud of them, but they would not be here but for that history. And I think it's important for us to point that out. Another piece here is that on our panel, we've got an attorney from government, we've got attorneys that are in-house, and then myself from a law firm. And so what we're going to do next is ask a series of questions to each of our panelists in series, and they'll certainly answer those questions and give you a little bit more background about themselves, but at least let me get started by doing a very quick introduction of our panelists here by name and at least their position and company. So first we have Christina Calloway, who's a senior trademark attorney, an attorney who's experienced in IP at the USPTO or US Patent and Trademark Office. That's the place to be if you're in IP, and certainly I think a cutting edge representative agency in deciding all that we care about a lot when it comes to the administration of IP rights. She specifically works in the trademark office, and we'll have a lot to say about that. Next, I'll turn to Izu Immiguali. She is a in-house counsel at JP Morgan. A lot of her career and what she does combines a lot of business and technology, and she works in particular with data and representing and dealing with clients internally, dealing with data initiatives and issues that they deal with. Also, we have Sharonda Rochelle of Microsoft, also a technology lawyer who does a lot of advising of engineers, management, and various professionals in the product development realm within Microsoft. So with that, let me start with my first question, and we'll start off with Christina. What are some of the exciting matters or types of matters that you're currently handling or maybe recently handled?
Good evening, everyone. Thank you again to the MBA, and thank you, Justin, for having me on the panel this evening. I think one of the exciting things is it's very hard to make a single statement about something that's exciting at the trademark office because it is the hub of everything that's going on in IP, right? It's the agency where you have to come to register your trademarks. So we are always at the center and hearing information, especially with the current ongoing pandemic. The biggest thing that I think we're working on is that people are still starting businesses. People are still making goods and services and providing those at almost an influx during the pandemic. This was a time, where people, I guess, wanted to catch their dreams and start businesses, and also the need for businesses and certain goods and services because of the pandemic. And I think that's one of the most exciting things now is like the work is continuous because that innovation, that creation is still there and always happening. We thought it might go down during the pandemic and it did the exact opposite. It exploded. So I think that is one of the most interesting things that we're dealing with right now is that people are still creating and innovating and they want to get those protections for those goods and services that they're providing.
That's great. Great answer. Izu, same question. What are some exciting things that you're working on or have worked on recently?
Yeah, so again, good evening, everyone. Izu Immiguali, thank you so much for having me on this panel, and hello to my fellow panelists, and thank you for allowing JP Morgan to be on this panel and help to plan and put together this organization for tonight. So I would like to talk generally about my work and what I really enjoy about the type of issues that I work on. Earlier, Charlie Bingham talked about his work in artificial intelligence, and there was a lot of mention of data and what people do with data. And Justin, in my introduction, you talked about how one of my primary roles is really to be a data counsel. And so in my role, what I do day to day is advise my data scientists, my business partners, and senior executives on how JP Morgan can responsibly use our proprietary information in-house, our client information, and also how do we negotiate with external parties to protect our information. So I'd say my hat or my role is all about the data, right? How do we make sure that data is being leveraged in a way that we can help our clients create better and faster products and services for our external clients? And then how are we making sure that we are abiding by our contracts with our clients as we're using their information? The last piece that I'd like to talk about is how do we also make sure that we are advising our technologists in their procurement of information as they're using it for the various artificial intelligence models that they're building. So how can we put on our legal and business hat to make sure that we are those trusted advisors and identify the specific risks and whatever we need to help mitigate those risks so the business can operate in a world where there really isn't regulation.
That's great. Sharonda, how about you? Exciting matters or types of matters that have been exciting for you recently?
Thanks, Justin. And as everyone else echoed, it's wonderful to be here. So thank you. So unfortunately, most of the exciting stuff that I'm working on is pretty top secret. So I can't really share like details. But I will say that I am on the amazing team that supports Windows at Microsoft. And that in and of itself is quite exciting to me, as you can imagine. I've been a tech attorney for almost 20 years, including before Microsoft, 12 years at JP Morgan. And I've had the chance to work on some pretty impactful matters. But I will say that the greatest satisfaction for me is knowing that the work that I do every day is used by the people that I love. So Windows and the programs and apps that run on Windows make their lives easier, whether it's for work, whether it's for school, whether it's just at home, taking care of home responsibilities.
So the impact of what I do every day, I see like when my daughter writes a story on her Surface device, or when my mother writes a letter to family members using Word, or my friends are on Teams conferences and sending emails from Outlook. So for me, that is what drives me, and that's what keeps this job exciting.
That's great. In fact, I was going to say it's so good. We should turn that into a commercial for Microsoft. So let me answer the same question for myself, at least from the law firm perspective. So a couple interesting or exciting things that I've been working on. It really focuses around one issue, and I can think of 3 different clients. And here's why it's really exciting for me. But I've been able to work on, whether it's for startups, medium-sized companies, or really big Fortune 500 companies, been able recently to answer the same question, which is, Justin, how do we improve our IP strategy? Or take a look at what we're doing. How would you, given that you've been part of litigation when things have gone bad, or when you've seen people do deals that work really well and kind of have an understanding of best practices, but help us over a period of time improve what we do in the way we do business? And I'll tell you that for me as an outside counsel is probably one of the most exciting things I can do, because as opposed to coming in, which is great too, I love all aspects of my work where you come in and help on a particular case or do one deal or agreement. One of the most constructive things you can do that I really have a passion for is building with someone or some entity over a period of time to kind of improve how they operate or improve their business over a period of time. And to me, that's really exciting. And I've seen that happen. Like I said, I think Christina mentioned it, that it's amazing that during the pandemic that in many ways innovation has not slowed down. If anything, people have got a little time on their hands to start innovating and thinking about doing new things. And so that happens in corporate life as well, and certainly happens to me experiencing as an outside attorney. So let me turn to the next question here, and it's sort of a corollary of the first, but I want to get a little bit more specific into some of the typical types of issues and matters that you handle that come across your desk. So let me start again with Christina. What are some of the typical types of issues or matters or projects that you actually have to really get into that come across your desk, maybe on a daily basis, or just something that sort of symbolizes a lot of what you have to do?
Yeah, so with the trademark office, and I believe that Danielle kind of mentioned it, touched on it a little bit before, is that statutorily we're dealing with likelihood of confusion. Just making sure that we're protecting the register when people are coming in or filing those trademark applications. And that's probably the largest thing that we deal with, making sure that we're protecting the register. There's not a likelihood of confusion. Someone is not coming in trying to use the reputation of another mark or something of that nature, as well as handling different and special marks that we have. I mean, we saw during this past year, as far as the pandemic, as well, a lot of social justice issues were highlighted, and even seeing how that comes into the office, how people want to capitalize and make money off of that, filing for trademarks for George Floyd and different names that we hear about, and making sure at the office that we have, we call special marks teams, that we're protecting even that before they even, if a family or a state decides to capitalize that, or not necessarily capitalize off of that, but protect those names, those images, that the office is on the forefront of that as well. It's not like it's just going to be random and then we do something about it, but making sure that we have an understanding of what's going on in the world, in our country, when people come in and attempt to make those filings. So that's kind of some of the bulk of what we're dealing with as far as now. With a pandemic, making sure that when we're protecting the register as far as PPE and things of that nature, that is coming directly into the office, that people are trying to protect that. We get to see what's coming, even if someone is doing an intent to use, where the office is going to see. I mean, those things are public record once you file a trademark application, but we are seeing what's coming into the marketplace, even on the entertainment side, or how everyone in most industries are having to pivot things. We're seeing that on the forefront. And I think that's the biggest thing, is trying to protect the register and making sure that as the examining attorneys, that we're being very diligent about marks that are already registered or applications that have come in prior filed, and making sure no one is coming up behind that. and trying to use the reputation or trying to use a registered mark in that way, or take advantage of something that's going on as far as social justice issues, using those names, using this family name or estate names and those types of things.
Okay, great. Okay, next to Izu. How about you? Typical projects or matters that come across your desk.
Yes, I can talk about three broad categories. One is, or the first two I'll combine together, is what are our data use rights, our data protection rights, and our data procurement rights. So protection rights, meaning when we are negotiating with outside parties and they have to use JP Morgan's information, I and the people that I work with, we partner to make sure that we have the proper terms in our agreements, that we are protecting our information, which can be highly used by any other third party. Then also our data procurement rights. Our teams may need information from third-party vendors in order to build their products and services. So I partner with our other colleagues in the legal department and the business as they're at the forefront negotiating those rights in order to make sure they have the information they need to build their new products and services. And the third area that I'm seeing across the desk is how do we advise clients on the potential legal risks as they're using artificial intelligence to, again, build different products and services? How do we educate them on what these legal risks may be? And then how do we also harmonize these risks across the globe? We are an international company. What the regulators are doing in EU as it relates to artificial intelligence and technology is very different than what we're doing from the government in the US. So how do we, from a global company, anticipate where we may be from a US perspective, but also looking at regulators across the globe to make sure that our clients that are building products that will touch all of our clients in different countries, that it is agnostic, or it takes into account what regulators are doing across the globe versus what we're doing in the US, and make sure we have those rights to properly advise our clients as they roll out these different products and services.
Okay, great. Sharonda, how about with you? Typical matters or types of matters?
So there are definitely certain common issues and themes in my work. Privacy is, of course, one of them. As Izu pointed out earlier, data is a hot commodity. And so, the need to ensure that it is used properly, protected, processed, controlled, and protected is a priority, especially as we have more of our interactions and activity occur via technology platforms. Also, I work directly with product teams and engineers. So I'm often dealing with inbound and outbound licensing and development matters, as well as open source. Also, if you've ever purchased a laptop or PC that runs on Windows, hopefully you have, you know that you have many brand and device options like Surface, HP, Dell, Lenovo. Part of my job is supporting that hardware ecosystem, which is comprised of all of those various companies who provide those choices that you have when you're in the market for a new device. So being a lawyer for that team comes with questions ranging from IP issues as we protect our own source code and handle source code from third parties, to marketing and communication, such as approving blog posts that relate to new technology, and ensuring confidentiality with respect to how much we share, and to competition law, as we try to keep a pretty level playing field for those partners who are part of our ecosystem. So just to Kibaru's point earlier, keep in mind that technology law encompasses a vast array of areas of the law. So you don't have to be a techie to be able to practice technology law at all. And this is especially the case because when it comes to SMEs who aren't necessarily techies or in that direct space working with engineers, we depend on them a lot once we identify areas where we need these subject matter experts to weigh in. So we have like open source experts and we have competition law experts and trade experts. So going back to that point, there's definitely a huge array of areas of law that sort of connect and inform technology law.
That's great. For me, I think on my end, in terms of just typical matters, you could probably categorize it in three ways. So one, a typical matter that I'm sort of dealing with is litigation. The point at which someone discovers, hey, I've been infringed, or in other cases, someone saying, oh my goodness, I just got sued for infringement. What do I do? Help defend me. So that's one sort of category, dealing with litigation. Another piece I kind of hinted at before, is more proactive, where people want counseling or advice or strategic thought on how best to leverage innovation or IP that they've come up with, or even how best to organize ahead of time in a new business or a business expansion. And then last but not least, another category that's always out there is more transactional. People are still doing deals, as you've heard about here today. They're still doing business, making alliances, agreements. And at every point, not only are they projects, services, products involved, but IP is a part of those agreements. And so many times dealing with different transactions or agreements that have an IP angle to them. So those are some typical matters for me. So the next question is very timely, given where we are in sort of our history in 2021. And it's really this: over the past year, and particularly with the pandemic, and this is for each of you, what are some of the biggest challenges you faced, and maybe some of the biggest positives that have come out of the pandemic, or all the other things that have happened to us over the past year? Let me start again with Christina.
I think the biggest thing, like everyone, is probably just across the board, is just the change in just your lifestyle, and your ability and freedom and certain things. Working at the USPTO, we had the ability to telework prior. So I was already on a partial telework. So that wasn't something that was such a shocker. But I think for the agency to move like 600 attorneys home, because all of us did not work at home, was probably a big shift in just learning how to have that capability. And I am a person who prefers to work in office. So I didn't have like this office set up at home. So even learning how to, I work in IP, but I am not a techie, and learning how to use certain equipment and making sure, because we wanted that transition to be seamless. Like we just talked about, the world, it felt like it stopped, but people were creating, that innovation was still there. People had to still maintain their trademarks, and were creating things that they were applying to obtain a trademark. So we had to still be seamless. Even with these ideas people already have about government offices, we are very, very big on customer service and still wanted to be available. So I think the shift wasn't that much of a huge deal, because we were still able to telework. We had already been doing that, but learning how to do that completely at home, online, shift your lifestyle at home. People have families and children, and they're homeschooling. So I think just across the board, it's hard to complain, because everybody in the country was going around the world, really was going through the same thing. So I think the biggest thing for me is also trying to manage that time that you have at home. I feel like sometimes people expect you to work a little bit longer, because it's like, well, you're at home, you're not going anywhere, or don't assume that you have anything else to do because you can't go anywhere. So just trying to make sure that you're managing and creating those boundaries of setting, this is office time, this is home time, even though I can't physically separate that making sure that you manage that time. So I think that is one of the challenges. But otherwise, as far as the office, it was pretty seamless because we already had those telework capabilities.
Okay, great. Thank you. Izu, how about for you?
Yeah, so similar to what Christina said, is setting those boundaries between work and your personal life. But the biggest thing that I miss is not having the time to disconnect during my commute. So I'm a native New Yorker. I never thought I'd say this, but I miss, but I do not miss riding the subway. So the subway, my trip to work, was a time to, decompress on my way to work, check emails quickly, but really decompress, think about the long day that I have if it's on my commute home, or think about the work day that I may have if it's on my commute to the office. But I don't have that ability to just disconnect, get lost in my thoughts after a long day of work, because you're going from your office or your kitchen or your dining room table to the TV in the living room, or to bedroom to go to sleep. So just having that time to decompress is what I miss the most. If we can talk about the positive sides, I like the ability to connect with my colleagues at different hours. So my role is a global role. I have colleagues, legal colleagues, and legal business partners in APAC. So the ability to just, maybe all calls are on Zoom, but, maybe put on a sweater or put on a robe, grab a cup of tea in the middle of later in the night to have a conversation with them from the comfort of my own home was helpful to just connect with them in the positive way. And because we don't have the commute anymore, I really enjoy the ability to get back on a workout schedule. So I've been able to take advantage of that in the morning. Now that I don't have to wake up earlier to hop on the subway that I miss, but really don't miss anymore.
Good stuff. Thanks. Okay, Sharonda, how about you? Pluses and negatives maybe from the pandemic.
So I guess challenges, and this goes back to something Christina said earlier about the innovating. I mean, my clients are engineers. They have been glued to their computers, like innovating out the wazoo since it started, which of course means I have more meetings and I'm stuck with a day of like back-to-back jammed meetings. And so the time to do actual work, I have to, I've learned that I just have to block it out and hope that no one tries to take the time, because otherwise, I find myself honestly in the evenings when no one can find me or ping me, and that I'm sneaking online and getting my work done. So I think that the challenge has been trying to navigate that space of more demand for your time, because people are innovating and you have to support them, versus being productive and feeling like everyone else said, there is a life separate from the computer that you're stuck to all day, even though you're still in your house. So that has definitely been a challenge. A positive for me, it has been the fact that I guess being part of a company that rose to the challenge of this whole thing. I mean, it was tough at the first few months, trying to have, we had to figure out how to get our engineers to be able to do their work remotely. They handle sensitive stuff. And so, this is renegotiating agreements and stuff like that, and making sure everyone's comfortable with all the arrangements, and then, creating checks and balances. I mean, it takes a lot to be able to create technology remotely in this environment and still stay ahead of the game. And so being a part of that whole mix, I think, has been super positive, because I've just seen the impact of it and how people have been able to work efficiently and get stuff done. And I'm on the internal team that we can sign up for teams and sort of the test cases, we can be the guinea pigs internally. And it's been interesting to be part of the mix of what features work, what features are convenient, so that these are the things that our customers will see, and we sort of test them out first so it could be a better experience for them. And I think that whole mix of things has been super positive to be a part of the solution to make everything easier for everyone in this whole pandemic.
That's great. I'd say for me, on the law firm perspectives, one of the challenges, and first of all, everything you all said, I agree. I see those in my life as well, even though I'm in a different sort of environment and context of the law firm. One additional one, though, I'll add that is maybe unique to law firms as a challenge is, if you think about it, particularly if you're starting the practice of law or joining a new team, law is an apprenticeship. How did each of us on this panel even learn what the heck we were doing? And so I'd say the biggest challenge on the law firm side that I've seen, particularly being a partner and in management, is it's real tough. Technology's helped us close a lot of the gaps, but it's real tough to take in new people, make sure they feel like they're part of the culture, part of the team, and get the kind of apprenticeship that you get when you're in an office with a bunch of other lawyers that are at different levels of seniority, and you can just literally walk down the hall into someone's office, or you bump into someone when you're going to the bathroom in a lunch break. You really don't get that as much as we try, whether it's through any of the video conferencing tools, and people can be friendly and make calls, but it just doesn't quite happen in the same way that it does when there's a group of you sharing a hallway or a set of bathrooms or a cafeteria. On the positive side, I would say this pandemic and everything that we've gone through has really shown what I think a lot of the younger generation has been saying all along, that, hey, we can telecommute, we can get work done, at least once we all know each other and have like a shared culture and a plan as a unit to go forward. But I think hopefully going into the future, we see a lot more liberal use of telecommuting. So we're getting a little short on time. I've got one last question, but we'll make it quick. And it's more, this is one for each person on our panel here. Based on where you sit now, what opportunities do you see, particularly in your field or where you work? And I think that's going to be particularly important for some of the young people listening, some of the people don't have to be young that are thinking about changing careers that are listening, and some of the folks that are even law students. But I'd be curious to hear from each of you, and I think our audience would, as to what do you foresee developing in your field going forward. So Christina, we'll start with you.
I think on the government side, and I'm just speaking in my personal capacity, is that because of that innovation and that constant creation, that the office is going to definitely have to consider, hiring more attorneys. There was a time that, that it had stopped, but for the most part, attorneys had to come into the office and be trained in the office. And that's not, of course, not occurring now. We're not in office. But if we have more work to do, if people are applying for more trademark registrations, you need more attorneys to handle that. So I definitely just, if working in the government on the government side is something that you're interested in, to definitely keep abreast and make sure you're putting those alerts in usajobs.gov if that's something that you want to do, and making sure that you have a grasp of working from home, what that's going to be like, what that's going to feel like Justin said, you don't have that collaboration as easily because you're not going to be around your colleagues. We can have video conferencing and those types of things, but making sure that you have an understanding of how to work from home and that you're comfortable with that. I think in any place you go now, if you happen to get a position, but especially on the government side with the USPTO, because we would do that regardless of the pandemic. So making sure that you have an understanding of how to manage your time and your life working at home, and also understand that work is definitely going to be there on the government side. I'm very grateful and happy and blessed that we didn't have to shut down. We didn't have to worry about that because people were creating and we were still getting tons of trademark applications.
Okay, let's turn to Izu. Same question.
Sure, yeah. So I would think in the data space, I would say hot topics or new areas would be an attorney that understands data use rights. That's the use of transactional information. Also privacy rights, the use of personal information, cybersecurity, how to negotiate, where the litigation risks are, and what IP rights are. If you can have all of those 6 areas, I think you're going to be a really great IP/tech attorney. And as our worlds continue to morph, you're going to be someone who will be very marketable for any company.
Good. Sharonda?
And I'll say ditto what Izu said. Plus, I will add telecommunications because of all of the online platforms for connecting people that will only expand. And also from a regulatory perspective, if you can sort of monitor the regulatory issues and the regulations globally with respect to privacy and cybersecurity and telecommunications, I think those will keep people very busy and very employed come in the near future, because I can predict that authorities will ramp up their regulations as this becomes a more permanent part of our lives.
Great point. And then last, I'll end it on the legal side in terms of opportunities I foresee in the future. So one, I think, is be prepared for much more pervasive use of technology. Video conferencing is only one angle of it. One thing we've talked a lot about this, and it's come up in each and every one of the presentations and the presentations before, has been either big data or AI. And I think the legal profession, being a lawyer and certainly being an outside counsel, it's already undergoing aspects of it that are being automated more and more and more. And I think attorneys now and into the future will do themselves a favor by becoming more expert at using that and trying to figure out how to harness the trends of automation in the legal industry going forward. So what we'll do next to move things forward is turn to the Q&A portion of this, and we'll turn to Izu to lead that.
Hi, everyone. So if any of the attendees have any questions, please feel free to drop it in the Q&A function at this time. If all the other panelists can please put on your cameras, you can ask a question to any of the panelists, the ones that did the deep dive, hot topics, Danielle, Justin, or any of the day in the life attorneys. I'll start off with the first question as questions may come in, and that is, do you have any advice to either practitioners who are on this webinar or law students as to how you reached to where you were in your career? Maybe we can start with Erica.
Yeah, I would say I think the really important thing is networking. I mean, I work at the intersection of music and technology, but many people on my team at Facebook are veteran music industry people, right? And they actually all know each other. And I actually got my role because one of my mentors knows the head of the legal team and personally put my resume forward. So I would say really building relationships. So when you meet someone, following up, doing the check-in, being genuinely curious about that person, I think is key. I also think getting involved in organizations like the NBA, like your local bar associations. I was very fortunate to be a member of the New York City Bar Association Entertainment Law Committee when I was a first-year associate. And the relationships that I developed as a member of the committee, I still have those now. And I would also just say leveraging, if you're at a firm, leveraging things like moderating panels, writing client alerts, being involved in the bar and writing articles and alerts, right? So that you can start to brand yourself as an expert on these topics. I think all those things are very helpful.
Thank you. And Sharonda, similar question, if you can go to you, what advice do you have for someone who wants to enter this particular field?
So my trajectory has been anything but normal. But I will say that I started on this path because I was open to something different. And I will say that, my career has run the gambit of being a transactional lawyer with technology deals, being a product lawyer. So especially with Microsoft, I've sort of come full circle, but there are so many different aspects of this space that you should just be open to trying out the different pieces of it. I think people think technology law and they automatically want to work for Microsoft, Google, or one of the big companies or something like that. But the reality is I got most of my experience at a bank. I was at JP Morgan for 12 years as a technology lawyer, and people, when I would interview, people would go, wait, you come from a bank? I'm like, yeah, I come from a bank, So I think just be open to where technology law can take you, the different industries, because once you can learn an industry, once you learn technology law and once you have that sort of spectrum of knowledge, but it does leave us so many options as far as what industries we land in or what we can cross. So just be open-minded.
Thank you. And we do have one question in the chat before we turn to other questions, and that is to any of the panelists, if you know, is it helpful to have a CIPP US certification to help aid your legal degree, so the privacy certification for the US? Any of the panelists have a thought on that?
I could take that. I think for certain positions at Microsoft, and we kind of talked about how data is driving everything, I think it's going to touch what Kibaru, I hope I said that right, brother. Come on and correct me if I didn't. Okay, Kibaru, it touches what he does, because for them to find out the bad actors, they're using data sets, and there's privacy and security regulations that govern what they can do with that. Same thing with Erica and the music. It just touches all of the fields. So it helps you that what is it? The IAPP, it helps to the employer to understand that you have a basic foundation of knowledge of security and privacy laws that govern data. And Izu, we did a panel together at your bank on data monetization. A lot of companies, this whole idea of data transformation or digital transformation is you have data sets, and a lot of times you're not efficient in what you're doing with that data, but you may, if you understand the laws, you may have an opportunity to either be more efficient in how you use that data internally, or you may be able to turn around and sell that data. And selling data is big business now. I like to tell people, if a product is free, let's say Clubhouse, Facebook, where you putting this data on there, somehow, some way, that data you are giving them, they can analyze that in some way. And not saying it's nefarious in any way, but that's business. They can find a way to make money off that data. So if you understand data security and privacy and what the laws say, you can help better guide your clients to figure out I mean, because the objective of business is to make money. How can we make money off this data that we have? So I think it doesn't hurt at all.
I agree with that. I don't have the certification. I'm not a privacy attorney, but I do agree with Charlie that it could be helpful depending on where you want to drive your career. So feel free to add additional questions. If not, I have one for Christina and Kibaru. Since you guys both mentioned that you're not tech attorneys, but you find yourself in the IP/tech space, can you just explain a little bit more about how you got your positions? And then Kibaru, you went into that during your presentation, and how did you find the skill sets to be successful in your career? Because I know you both are successful in your career thus far.
I would just start with the same thing that Erica said. It's going to be networking. There is this, well, when I was I knew I always wanted to work in the government, but what you would hear about the federal government is that it's hard to get into, it's hard to crack into. Once you're in, it's easier for you to move laterally or go into different agencies. And I did find that. I graduated from law school during a recession. And I did find that it was difficult to get into the federal government if you didn't have some type of priority, whether you're a veteran or something where they were considering that when you were applying. So I think the biggest thing is to network. If you are part of any voluntary bar associations where you are, making sure you're maintaining relationships with professors that you may have had or in certain classes, whether they're your IP classes or what have you at your law school, definitely networking. And that is how I found my position. Someone was working, was actually like the cousin of someone that I had a relationship with. And she was like, my cousin works at the trademark office, but she worked in Dallas. I was based in Georgia. I got in contact with her. I've literally never met her in person, but we have a relationship because we would talk on the phone, and she kind of helped prep me for this process and going through the interview process and sending me the notifications when it was time to apply. And I've worked with her and kept maintaining that relationship, although I've never met her before. I know her cousin, but just through that relationship, I was able to find out about this position, something I didn't really look into or know about before then. So I definitely piggyback off of Erica to say that you maintain those relationships, because it is about who you know sometimes, and making sure that when you're maintaining those relationships, being genuine, like she was talking about, so that if they had to write a reference for you, or if they have to speak with someone else that they know about, you, that they're not just saying, well, I just talked to this person, I don't know who they are, I don't know what they do, I don't know anything about them, that they actually have a genuine relationship with you and can kind of advocate on your behalf when you're applying for different positions.
Great, thank you. Kibaru, anything to add?
Yeah, I would just add on, and before I do that, I would like to just add another area of growth that I think we should name for the attendees, and that is e-commerce compliance. I think that is another area within the IP space that we will continue to see metastasize and grow, and that there's going to be a legal need to help some of these companies that are doing e-commerce build programs to protect their customers, like what we're doing at Amazon. But as it relates to my path, I would just second and plus one what Erica, Christina, and Sharonda said. My path was not direct. I mean, people ask me today, Kibaru, you went from being a state prosecutor doing DWIs to a federal prosecutor, and now you're the director of Amazon's counterfeit crimes unit. One thing I would say is just make sure you identify what skills are portable to an in-house or firm setting, wherever you are, because once you can go in and you can lay those out in almost like an elevator pitch, it will be persuasive, and you will be able to say, day one, when I join this organization, this is what I can do and bring a value. As the director of counterfeit crimes unit, I was able to say I've prosecuted criminal organizations who have counterfeited, who have sold counterfeit medicine, pet medicine, iPhones, and I have relationships with rights owners, companies, and have worked with outside counsel and firms on behalf of those companies, right? And when you can say things like that to a major corporation, and they know day one you can help stand up a platform or a program, and you can call federal prosecutors across the country and law enforcement across the country, those types of skills that are portable will open doors for you. The second part I agree is the networking piece. Anytime you get a chance to, be on a panel, write an article, meet someone for a virtual coffee, do it. And, you know, LinkedIn right now is an amazing tool that many in the audience you have that we didn't have coming up. And you can easily send a note and say, hello, Kibaru, I see you're at Amazon. You're director of the Counterfeit Crimes Unit. I love fashion. I want to do brand protection and I want to merge that with the law. Can we talk for a virtual coffee? Mm-hmm. The likelihood is 10 times out of 10, Kibaru is going to say, you know what, let's schedule 15 minutes to talk. And doors will be open that way. So that networking piece is huge. Funny story, kind of like Christina, the person who brought me over to Amazon, we worked together at CSIPs at the Computer Crime Intellectual Property section. She came over to join Amazon. She recalled a conversation we had about a trial I had and me one time going by her office and just checking on her. She said, Kibaru, that resonated with me, your background and just your personality. And I said, I got to have him on my team when I left the department to come over to Amazon. Things like that, those seeds that are planted, they matter and they take root. So those are my suggestions.
Thank you, thank you. So I'll turn it over now to Danielle for announcements and then we'll do closing remarks. But thank you everyone for your time and contribution to this panel.
Thank you, Izu, and thank you again to all of our speakers and everyone in the audience tonight. We hope this event helped to provide both substance and insight. As mentioned earlier, one of the goals of the IP section is to host educational events and facilitate connections. As I say, your network is your net worth, and I think that's so true, especially given the comments by our panelists tonight. So let's make it a goal this year to get to know each other even better. With respect to announcements, the IP section will be opening our nomination process for our annual Diversity in Tech and IP award ceremony on March 15th, 2021. So keep an eye out for that announcement. In the meantime, you can find details on our website located at diversityintechlaw.com. Our award ceremony and this year's National Annual Conference will both be virtual, and we hope that you can join us. Thanks again, and back over to you, Izu.
Yeah, thank you so much, Danielle. I was going to say again, thank you to all the panelists. Thank you to the attendees. Thank you, Justin and Danielle, for organizing it. And on behalf of JP Morgan, we are a partner for this organization, the Legal Diversity Council. I am co-chair of the External Bar Relationship and Recognition Sub-Council. We just thank you all for your time and look forward to partnering with you again. As I think Christina mentioned, and even Erica mentioned, it's important to get involved with our various bar organizations. So we hope that those of you who are participating and the panelists, if you haven't already joined, that you'll consider joining the IP section of the MBA. Thank you all. Have a good and safe night.